America was created by people who understood that power unchecked is power abused. That's why we have a separation of powers, the Bill of Rights, and the right to your day in court. The law firm of Bursor and Fisher believes in that creed and makes it possible for average Americans and thousands, even millions, of everyday consumers to have their day in court by taking on cases to fight for justice against corporate giants like Verizon Wireless, AT&T, Singular Wireless, Sprint, and T-Mobile, as well as purchasers of Avocor and Zenadrine products. Today, the Insider Exclusive takes an inside look and visits with one of America's premier law firms, Bursor and Fisher, and its founding partners, Scott Bursor and Tim Fisher, and their amazing record for getting justice for millions of consumers in record-breaking class action verdicts and settlements. The firm has offices in California, Florida, and New York, and as advocates for the people, they believe it's important to fight for a cause. They fight for the rights of victims and champion the underdog against corporate power and greed. And in every case, and with every client, the Bursor and Fisher lawyer litigation machine devotes itself to getting justice for their clients. They are tireless and fearless champions for those whose rights have been violated. They are driven to fight for people who have been harmed by the willful or negligent actions of others. Bursor and Fisher are proud of their legacy of excellence, representing ordinary people who may have limited or no financial means to devote to the cost of litigation. They fight for the underdog, because injustice anywhere is a threat to justice everywhere. And justice and power must be brought together so that whatever is just may be powerful, and whatever is powerful may be just. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Walnut Creek, California, at the law firm of Bursor and Fisher. It's my great pleasure to introduce Scott Bursor and Tim Fisher to the show. Welcome to the show.
Thank you, Steve.
Thank you, Steve.
You're primarily known as class action lawyers. There's kind of two lawyers in the world, the ones that represent individual people and the ones that represent class action, or a group of people. You've had a number of great successes in some of your class actions. Talk a little bit about them. You had the Avocor settlement.
Well, Steve, I mean, first, we represent real people too.
Yeah.
I mean, in every case, in every class action case, there's a real person who's the named plaintiff that we represent, who has been involved in, it could be they had a charge on their phone bill that shouldn't have been there. Could be they bought a drug or a dietary supplement that wasn't marketed the right way. So we represent real people who have claims that affect not only themselves, but similar things have happened to a large number of people. And so we try to get those cases certified as class actions.
Basically, it's group litigation, isn't it? For the layman that's unfamiliar with the word class action. It's a way that the little guy can get justice for a small amount of money, usually. But there's could be hundreds of thousands or millions of people involved, right?
That's right. I mean, you're talking about representing real people. We represent nothing but real people. Sometimes we represent millions of real people all at once. We will represent more real people in our cases than most lawyers will represent in their entire careers. So yes, the classes are composed of many thousands and sometimes even millions of people who have all been harmed in about the same way. That's what a class action is.
And some of them were against Sprint, against Verizon, against who else?
We've gone up against big companies.
Yeah.
I mean, Sprint, Verizon, AT&T, T-Mobile. We've done dietary supplement companies, Global Vision Products, the company that sold Avocor, Cytodyne Technologies, a company that sold the Zenadrine diet pills. We've done a whole range of class actions against big companies, little companies, and companies in between.
When you take on AT&T, when you take on Sprint, when you take on Verizon, they have a whole battery of lawyers, don't they? And that must be pretty formidable, isn't it?
It can be.
Do they bury you in paperwork or what?
They certainly will try to do that, but we respond to that by always trying to be aggressive in our cases and trying to be proactive and dictating the tempo of the litigation rather than letting the defendant do that to us.
And how do you do that when you say be proactive and dictate the tenor of the litigation?
We try to move the cases forward as aggressively as possible and let the judge know that we want to move this case forward as quickly as possible. So
and they try to slow it down.
Defendants always want to slow a case down because while a case is in court, idling in court, they're not having to pay any money. We want to get to the finish line as quickly as possible because we want to get money back to consumers as fast as we can because people have been ripped off and they deserve to get their money back fast.
Now, you've represented in some of your class actions millions of people, haven't you?
We have, and you brought up the Sprint case where we represented a woman who was charged a $200 termination fee on her Sprint cell phone contract, and she thought that was an illegal penalty under California law, that was an illegal fee.
Had she fulfilled her contract, or she was terminating early?
She had terminated her contract early,
Yeah.
and Sprint said, well, we have a contract that says you owe us $200. And we came in and said, well, wait a minute, you're not allowed to have a penalty in a contract. If they didn't suffer any actual loss from you terminating, that's an illegal fee. And it wasn't just one person that was charged a $200 fee. There were 1.9 million people in the state of California between 1999 and 2007 that were charged the same fee.
Right.
And so we took that case, we advanced the expenses for the case, we worked on it on spec, we didn't charge the plaintiff a dime, and we litigated that case for, well, it's still going on through the appeals, but we litigated that case for more than 7 years. We took it all the way through to a jury verdict where we were awarded $299 million on behalf of a class of people who had been charged that illegal fee.
Now, there's 1.9 million people in the class. How many people do you get information from 1.9 million people? I mean, that seems like a lot of paper.
Well, there's really two parts to that. There's
Yeah.
the people who are the class representatives in the case, and that's just a few people.
Those are the ones you deal with all the time.
Those are the plaintiffs whose names are on the complaint and represent the class.
Then you get the records of everybody that would be involved.
And then from the defendant, we will request information about every person who is involved so that we can contact them when the class is certified, so we can get money back to them when there's a settlement or we prevail at trial.
Do all of, for example, in this 1.9 million people in this class, have all of them responded to you in reference to this class action?
No, not at all. This is a case where a notice was given to them sometime in 2006.
Yes.
The notice went out. The case actually went to trial in 2008. But they don't respond, they're not required to respond, and in fact, one of the things in the notice says, if you do nothing, you'll be fine, you'll be in the class, and if money is obtained, we'll let you know later.
Yeah.
The only reason to respond is if you want to opt out of the class, which usually is not a good idea.
If you don't respond, are you, when the thing is finally settled, are you going to get a check in the mail?
Yes. Well, if the case settles for money,
Yeah.
which the Sprint case has not. The Sprint case is still on appeal. But we had the same case against Verizon Wireless, where we represented a class. I think that class was about 1.7 million people.
Well, how much was that? 21 million, was that right?
We settled that case for $21 million, and that money was distributed last year. There were between 200,000 and 300,000 people responded, sent in a claim form, and they got checks for somewhere between $70 and $80 apiece.
How do class action lawyers usually get paid?
The cases are handled on what's called a contingent fee basis, which means that we don't have clients who are paying us by the hour because, as we talked about, if you've been ripped off of $200 or less, you can't afford to pay a lawyer to work 1,000 or 2,000 hours on a case. It just wouldn't make sense. So what happens is at the end of the case, if there's a settlement or we've prevailed at trial, we ask the court to award us a percentage of whatever's been recovered.
We're going to discuss two of your cases. One of them is the Avocor, and we have with us today the lead plaintiff, Jim Thomas, and we're going to bring him on right now so we can talk a little bit about that. It's my great privilege to introduce Jim Thomas. Welcome to the show.
Thank you.
You were the lead plaintiff in the Avocor class action suit that Tim and Scott were involved with. Tell us a little bit about what was your role in this case.
Sure. As lead plaintiff, my job is to take into consideration the class, be basically the representative of the class. So not only my situation, but also looking out for everybody's interests.
Yeah, when you bought Avocor, you never even dreamed that this would lead to this, right?
No, when I purchased the product, I wanted to be one of their millions of satisfied customers.
Right? You didn't want to be a witness in a trial.
Correct.
And speaking of being the lead plaintiff, the judge has the ability to award incentive awards, correct?
That's right, and that's an important part of the process, Steve.
And then and that encourages people to come forward, and as a result of this case, you were awarded a pretty nice sum, weren't you?
Yeah, I was actually awarded $25,000 for my pet rock status, as it was known in the trial from the other side.
And that should encourage other people to come forward. It's almost like a whistleblower kind of a thing, isn't it?
Absolutely, that really is a good analogy, Steve, because we're asking a few people to step forward and represent thousands, sometimes millions of people. And that's a hard thing to do. People are busy, people don't have a lot of time, and they just say, geez, why should I bother doing that? But it's not just about the principle, it's about standing up for justice and for the right thing. And we try to teach our kids right and wrong and standing up to people who do things that are wrong, and that's what the class plaintiffs do.
Do you remember the movie Network, where the newsman says, I'm mad as hell and I'm not going to take it anymore?
Right.
You got that same feeling, didn't you?
I did, yeah, and it was kind of frustrating, some of the tactics that the other team would use, the defendants team. They would, and I guess they were even breaking protocol, is they ended up serving me directly at my home during my son's birthday party, and it was, they were, I don't know if they were trying to scare me.
They asked a lot of irrelevant questions in the depositions, right?
Yeah, the deposition was ridiculous.
The message really is, don't be afraid of all that, right?
Yeah, they're just trying to push you around the little guy. They're hoping they scare you off.
Yeah.
And they were threatening. They wanted all my financial records. They wanted to make sure that I personally had enough money to fund the entire trial. And they were really pushing me.
It's unbelievable.
Really?
It's just.
So what did you? They contacted him directly. He was represented by you. So.
Yeah, they contacted him directly, which is a violation of California law, and we were outraged by it. And it was really just an attempt to intimidate him and to try to scare him. And that's something that, that was an outrageous example, but that's something that defendants will try to do in these cases. And that's, a big bully trying to squash the little man.
Yeah.
And that's really, what we're trying to fight against in these cases.
I want to thank you very much for representing the little man, 150,000 of them. And I want to thank you very much for being on the program, too. It's my great privilege to introduce H.P. Schroer. Welcome to the show.
Thank you.
H.P., you were represented by Scott in another case, another class action, which was against Verizon, wasn't it?
Yes, it was.
Tell us a little bit about what happened with you and why you became involved with this case.
Well, like your viewing audience, I felt that the only people in class action cases were those of the attorneys that made money, and the class itself was not truly representative.
In other words, the everyday average person didn't get anything.
Right. And I was motivated to get involved in a class action because Verizon, I thought that the early termination fee was illegal.
Well, let me ask you a question, and I'll ask this to you also. It is in their contract, isn't it? Is it in their contract?
It is in the contract, Steve, but
just because something's in a contract doesn't make it legal, right?
Right. You can't have a contract, for example, to sell your baby.
Okay.
You could have it. That might be in the contract, but that would not be a legal contract. You can't have a contract to sell yourself into slavery.
Yeah.
So there are certain things that the law does not allow.
And that's one of them.
And one of the things the law does not allow is a contractual penalty. You can have an agreement that says if someone breaches, this is the amount of damages that they will have to pay, and that's called liquidated damages. But it has to be based on a good faith estimate of the actual loss that the breach would cause. And what we proved in the early termination fee trials against Sprint and against Verizon was that the early termination fee had no relationship to any actual loss caused to the carrier, and it was arbitrarily set at an amount that was high enough, just high enough to discourage people from leaving the company. It was not a mechanism to compensate for a real loss. That's why they were illegal.
HP, when you got this early termination fee, you just thought that was wrong, right?
Yes, and I refused to pay it. And what happened is that I was put out reported to the credit reporting agencies, which has some consequences attached to it because my credit was impaired.
You were blacklisted.
Yes.
By other phone companies?
No, because I didn't apply to other phone companies at that particular time.
And this was all over how much money?
The early termination fee was $150.
So for $150, they reported you to the credit agencies as not being a responsible person.
Right. I was essentially a deadbeat. And so I complained to the FTC, the FCC, the Attorney General. I wrote to my representatives, and it was by virtue of a letter to the FCC wherein I registered a complaint that I heard from Verizon. And they told me that they were canceling the early termination fee, and they were going to notify the credit reporting agencies that the charge had been canceled.
Yeah.
And I said, fantastic. I said, are you changing your policy now? Is everybody going to be notified? And they said, no. We're making an exception for you.
And did they do it?
Oh, yes, they canceled it. They made an exception for me, but they did nothing for everybody else.
So you were taken care of, but you went beyond that, didn't you?
Yes, I was so ticked off that I was going to become my own attorney, which is something that someone should never do. So I did some internet research, and through that I got in touch with Scott.
Right.
And what Scott did by virtue of the early termination class action suit is made my voice and Ms. Brown, gave us the voice of 4 million. I think the number, you would know better.
Ultimately, we did a nationwide settlement that was several million people, yes.
Several million people. So we, in turn, were speaking for your listeners out there, 4 million of them.
So
without Scott,
yeah,
that voice would have been a voice in the
well,
wilderness.
I really admire, you were taken care of, but that wasn't good enough, was it?
No.
You wanted to have other people taken care of. And that, you see, that's what this show is all about. We have the lawyer, Scott, who stands up and represents people who are unable to stand up for themselves. They don't know the right paperwork to file or whatever. And we put these big companies to test. Well, you had the persistence, you found the right talent, and I want to thank you very much for appearing on this show. Recently, the United States Supreme Court has made some decisions in some class action cases. One was in favor of AT&T Wireless. There's some other ones that are pending against Walmart, for example, that they're taking into consideration. What is the future of class action lawsuits in America today?
Steve, that's a very open question right now, because last week the Supreme Court decided AT&T versus Concepcion. And that was a case where some customers had sued AT&T in state court in California. AT&T responded by saying that they had a mandatory arbitration agreement as part of their customer service agreement that forbade class actions. And the state of California had long recognized, as has many other states, that agreements like that are so one-sided and so prone to abuse that they could not be enforced. And AT&T made the argument in the Supreme Court that the state law rules against enforcing mandatory arbitration clauses with class action waivers were preempted by the Federal Arbitration Act. If that ruling had been made 5 years ago, the cases that we had challenging the early termination fees, for example, that led to reform in the entire industry, would have been thrown out of court immediately. And so it's a very open question whether the courts are going to permit companies to basically have a get-out-of-jail-free. It's a contract between AT&T and the customer that the customer never sees, never signs. It's terms and conditions. Maybe they come in the mail after the fact. Maybe they're on a website somewhere. And what the effect it has is it says you are not permitted as a customer to go to any court in the United States of America and bring any claim against us in any capacity whatsoever. And it's not just AT&T that has this. Every wireless carrier in the United States has the exact same provision in its contract. Every cable company in the United States has a similar provision. Dish Network, DirecTV, and with that decision last week, what it appears to have said is we're going to allow those to be enforced. And if that's right, it's going to be very, very challenging for anyone to seek any measure of justice if they've been cheated on their phone bill, if they've been cheated on their cable bill. And we talked about the Avocor company, where they're selling a grossly fraudulent hair regrowth product that was actually a scam. If they had just put in some literature in the package that said, we're going to arbitrate any disputes and there can't be any class actions against us, we never would have been able to get off the ground.
Right.
And they can just go on committing fraud after fraud after fraud without any redress.
So consumers still have an effective way of acting together to sue these big companies, right?
They still do, but the Supreme Court's action has narrowed those rights and made it more difficult. And there will be circumstances that may arise where it'll be harder for consumers to have their day in court and to have their rights vindicated and to stop companies from taking advantage of them.
It just makes it more important for someone who's in that situation to make sure they get the right lawyer.
We've done an outstanding job, and I really appreciate you spending time with us today. Thank you very much, both of you.
Thank you,
It's
Steve.
a pleasure, Steve.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.